Yes,
And the
sir.
last thing you want to do is talk over me. And you're still being argumentative, even towards me. It just needs to be taken down a notch. Coming at it aggressively might not be the way to do it.
It is discoverable and relevant to the case.
That's what I just said. You seem very frustrated, and I'm not sure why.
I'm confused why there's pushback at all.
Well,
And that is alarming to me that we would have to even compel anything.
if you'll sit around and watch today how everybody gets along. Hold on.
This defendant made a serious error in judgment. She showed up to court with the very person she was legally forbidden to be around. According to the case details, he's the individual listed in her bond restrictions, yet he was the one who actually drove her to the hearing that day. That single decision changed everything. As seen in the opening footage, things took a sharp turn when that same man suddenly stood up and began shouting from the back of the courtroom. What should have been a straightforward hearing instantly descended into chaos. The interruption caught everyone off guard, and you could see Judge Simpson trying to make sense of what was happening. The most shocking twist came when the judge realized who the man was. The moment that connection was made, any chance she had of walking out free was gone. Just seconds earlier, she was on track to leave the courtroom without further punishment, but once Judge Simpson identified him as the very person she was ordered to avoid, the entire situation flipped upside down now. She's facing potentially severe consequences for violating her bond terms, all because she underestimated how closely the court watches these conditions. It's a reminder that in the justice system, even one careless decision can carry serious weight. So what are your thoughts on Judge Simpson's reaction in this case? Do you think he handled it fairly, or should he have been even stricter given the circumstances? Drop your opinions in the comments below. This one's definitely worth a discussion. Alright, let's break down exactly how this situation unfolded and what might happen next.
All right, this is cause number 1830854. And sir, you're Juan Sanchez?
Yes.
And so we're here today on a motion to compel, and before we get into a whole lot, I've done a lot of my own research and looking at all of this, and a couple of things. One, I don't believe the subpoena ducis tecum was the proper way to try to get the information. Ducis tecum is an order to get somebody to bring something to a set hearing. So, but we didn't have a set hearing, and they weren't ordered to give it to at a set time for a hearing. So, under the rules that have to do with subpoena ducis tecum, I don't know that that was the proper way. I do think you're entitled to some of that information as a defense attorney. If we're going to base decisions on, if I'm going to base decisions on things that probation have in their file and that they're just going to tell us, I do believe that you are entitled to some of that information. I think the proper way to do it would be to make that request through the district attorney's office for discovery. And then for you, Mr. Nichols, to make those requests, and then I would approve you guys giving whatever records are requested within reason. But lab results, testing, money owed, all of those types of things, I think are probably discoverable and something that Mr. Franklin needs. I just don't think this was the...
I agree, Judge. Any of the things that pertain to, well, I do think it's discoverable. In this case, it's all allegations on the motion are based on arrest out of county. And so his attendance record and all that, I don't know why we're subpoenaing the entire probation file when it's not even part of the allegations for the motion.
May I respond, Your Honor?
Well, let him finish, yes.
He did subpoena Wharton County records, so a representative from probation down there came in today for this hearing. I have no problem with getting him all that stuff. A lot of it's not in my possession. The out-of-county offense reports and things like that, I don't have yet. I would have them if we move towards a hearing where I prove up those allegations, and they, of course, will be provided beforehand. And again, I don't think he's not entitled to have all that stuff. So
sure. I
kind of agree with that. I don't want to subpoena. And Mr. Franklin did make just a standard discovery request at the onset of his involvement, which was early May. I don't have anything really responsive to that at this point.
Okay. So obviously, if it's based on a new offense out of another county, that's something you'll need to work towards getting and get that to Mr. Franklin. And so that needs to take place as quickly as possible. Because I don't know, I guess, Mr. Franklin, if there's not an allegation in the motion to revoke with regard to certain administrative violations, and there isn't an allegation, then why would you, what is your argument that that would be relevant or discoverable?
Your Honor, my client is wanting to stay on probation. and the court may take into consideration his performance while on probation, including his payments, his report, and everything else. So as part of determining the motion to revoke, it is relevant to look at his performance while on probation, particularly when he is requesting to stay on it. And he's been on probation nearly 6 years, I think over 5.5 years, nearly 6 years. And that performance will be helpful in determining or mitigating whether he stays on probation or if the court decides that he goes off of probation, and perhaps mitigating any potential sentence.
Okay, I don't disagree. So, again, though, I think the way to do it would be to make that request. I mean, and I don't know what conversations y'all have had, but make the request. I think coming at it aggressively might not be the way to do it. Sometimes you get more with honey than otherwise. So make the request to Mr. Nichols. If he says no, then let's go through what we need to go through.
She was just moments away from walking out of that courtroom when everything suddenly unraveled. What was supposed to be a routine hearing turned into one of the most unpredictable court moments I've seen in quite some time. The entire atmosphere shifted from calm to chaos in a matter of seconds. The most shocking part? The very person she was ordered to stay away from was sitting right there in the back of the courtroom, speaking out loudly as if this was some kind of family argument instead of a legal proceeding. It was surreal to watch, and for some reason, he seemed almost amused by the situation, grinning like the whole thing was a joke. Meanwhile, she looked completely mortified, clearly realizing how badly this was spiraling out of control. At that point, it was hard to see her as entirely innocent. The embarrassment on her face said it all. She knew what was happening wasn't right. And the expression on Judge Simpson's face? You could tell he was caught between disbelief and frustration. I've watched countless hearings with him, and I've never seen him react quite like that. It was the look of a judge who had truly run out of patience. What makes this situation even more unbelievable is that she admitted he was the one who drove her to court. That's not just bending the rules, that's breaking them outright. She had freedom within reach, but instead of walking away with a clean slate, she made a choice that completely backfired. It's almost as if she didn't take the bond conditions seriously at all, like she thought they were just suggestions instead of court orders. Judge Simpson had been giving her every chance to make things right. He was patient, even understanding, up until that moment. But it's tough to help someone who keeps sabotaging their own opportunities. Out of all the questionable decisions I've seen in bond hearings, this one might take the top spot. It's a textbook example of how quickly good intentions can be undone by poor judgment. In the end, it really raises the question, was she genuinely unaware of how serious this was, or did she think she could just get away with it? Let me know what you think in the comments. Was this a simple mistake or a deliberate move that backfired? Either way, we'll soon find out how Judge Simpson decides to handle this situation, and whether he believes another warning will make a difference, or if jail time is now on the table.
But let's try to do this amenably. The ducis tecum is not the way to do it unless it's set for a hearing. That's just the rules of evidence, and
Yes, Your
so
Honor.
that's not the way we're going to do
The
it.
ducis tecum was set for the day that it was initially set for a hearing, and it did specify that date for the hearing, I believe. And we ended up moving the hearing date because of conflict.
And Judge, I'd ask Ms. LeBeau to go ahead and get everything together today
Yeah.
to turn over.
I mean,
Unless
yeah,
there was something that the court was ordering her not to turn over.
I don't think on this list that there are. I mean, is there anything that y'all specifically had an issue with?
Ms. LeBeau, is there, or do you have any concerns you want to
If there's,
make the court aware of?
Your Honor, we don't have to list those. We filed a 3914 discovery request. This was belt and suspenders because we didn't get any of the information relating to probation in our 3914 motion originally. I would also note that the chronological.
well, and these aren't. The reason you didn't get any of those is because those aren't his; they're theirs, and so they're not. I don't think Mr. Nichols has the ability legally to make probation give them those. I think once we talk it out, though, I think whatever Mr. Nichols, y'all get together. Obviously, offense report. If y'all have the offense report and you don't even have it, then you need to get. I mean, that's
Right, I mean,
that's great.
it's
Everybody
all
can
stuff-
get the information in an amenable way. So let's do that. Y'all sit down. I want everything that you have that is. I don't know that there's anything I can think of that would be
Unless, I mean, I guess
Not-
notes may be work product, but I'm not real.
That's what I'm thinking about, but it's
Not
not
too
really
concerned.
attorney's notes, and so I don't know that that would be
I
an
would object to
issue.
that, Your Honor, on the grounds it's not attorney work product. It is merely work product of an employee, and it is discoverable and relevant to the case.
That's it. And that's what I just said. You seem very frustrated, and I'm not sure why. I mean, I don't know.
I'm confused by if there's pushback at all on any request for a 3914 discovery when he's constitutionally allowed to access those files. It should just be produced by probation without a fight. And we got a letter anticipatorily repudiating any production of discovery, and we had to file a motion to compel to that effect.
Well,
And that is alarming to me that we would have to even compel anything under 3914.
This is not something that a lot of attorneys have done in our cases. And so if there is something, if you'll sit around and watch today how everybody gets along, hold on.
Yes,
And
Your
the
Honor.
last thing you want to do is talk over me.
Yes, Your Honor.
So I'm standing here or sitting here saying that I agree with you, and you're still being argumentative even towards me. And that's not going to get you anywhere. Hold on. Being argumentative with Mr. Nichols isn't going to help Mr. Sanchez. Being argumentative with these ladies isn't going to get you anywhere. I agree that you're entitled to this information. I just think there's a better, less argumentative, defensive way to do it. They were told to do what they were told to do because their understanding of the law is what it is. So I don't disagree that we needed to all get together, but it just needs to be taken down a notch. So I want the stuff turned over to Mr. Nichols, and then Mr. Nichols will turn it over as discovery. I'm not going to have probation start turning it over to the individual attorneys in cases, because I think the proper way to make sure it's in the portal, that everybody knows what the discovery is that they've received, so that it's electronic when you sign your any type of documentation, whether it's at a hearing or a plea or a trial of what you've discovered, that it goes through that portal so everybody knows what everybody's got. So y'all get it to Mr. Nichols. Mr. Nichols will put it in the portal, and then you will get it. Once you get that, if there's something that you think is not there, then contact us. We'll have a hearing if necessary. Contact Mr. Nichols. Hey, what about this? If it exists and he says no, then let's have a hearing about it. Okay? So y'all get that done, and then we'll reset the case for just an announcement in a couple weeks or so. Fine with that?
That should be fine, Judge. We'll be able to
Okay.
get everything scanned in and provided through the portal.
Perfect. Thank you. All right, y'all are all excused.
Be needed
I'm sorry. No, ma'am. If you'll just get what you need to Mr. Nichols, unless you are personally subpoenaed to be here for a hearing. Now, and on that date, we won't have a hearing on that date. So if we come in and there's pleas of not true, and we're going to have a hearing, we can come in on that date, enter pleas of not true or true to certain allegations. Then we would reset it for a court date. And at that point, if you need to be here, let her know. If you need a subpoena, then you can get a subpoena. If you just need us to let you know you need to be here, then we can do it informally. You just let us know, or let Mr. Franklin or Mr. Nichols know what your employer will require for you to be here for an actual hearing. Okay?
Yes,
Good?
Your
All
Honor.
right. Thank you, y'all.
Thank you.
Honestly, the outcome of a hearing was lighter than most people probably expected. If someone else, especially a man, had been in her shoes, the results might have been far different. But the way she carried herself in court gave off a sense of uncertainty rather than threat. She didn't come across as someone dangerous, more like someone who made a serious mistake. And it seems Judge Simpson may have recognized the distinction when deciding her sentence. From the outside, she gives the impression of being harmless or maybe just inexperienced, but appearances can be deceiving. None of us truly know what's beneath the surface. Still, the judge's decision reflected a careful balance, recognizing both accountability and the opportunity for her to learn from this situation. Now, about those bond conditions, they couldn't be clearer. If a court orders you to stay away from someone, that's exactly what it means. You don't contact them, meet them, or, in this case, have them drive you to court. That's not a misunderstanding or coincidence. It's a direct violation of a standing order. Yet despite that, she managed to avoid the harsher consequences many thought she'd face. The GPS tether requirement seems like a smart and measured choice. It's firm enough to remind her of the seriousness of her actions, but not so severe that it derails her entire future. It's a second chance, one she'll hopefully take seriously moving forward. In a way, it's the court's version of a warning bell. Time to straighten out before things go further downhill. So what do you think? Did Judge Simpson make the right call? Or was this decision a bit too lenient? Share your thoughts down below. I'd love to hear your take on how this case was handled. Thanks for tuning in, everyone. Don't forget to like and subscribe for more updates and courtroom breakdowns. And if you've made it this far into the video, drop the word Michigan in the comments. I'll be replying to everyone who does. Your support really means a lot, and it keeps this channel growing. Thank you for being here.